Yesterday, a panel of the United States Court of Appeals for the Second Circuit heard oral arguments on Trump's appeal of the first Carroll jury verdict that found Trump had legally defamed Carroll in October 2022 when he claimed that she had fabricated a sexual assault claim against him. The jury awarded Carroll $5 million in damages, and that included only $300,000 in punitive damages. I read the briefs submitted by the parties to the appellate court, and those are available for review online. Trump is primarily claiming that the district court erred in making several evidentiary rulings during the trial. The primary errors claimed by Trump's attorneys were allowing the jury to see the Access Hollywood tape and permitting two women to testify about how Trump had allegedly sexually assaulted them. While it is not possible with absolute certainty to predict how the appellate panel will rule on those evidentiary matters, I doubt that the arguments that Trump's attorneys have made will lead to a Second Circuit reversing the jury verdict in the first Carroll trial. Rule 415 of the Federal Rules of Evidence provides that in a civil case involving a claim for relief based on a party's sexual assault, the jury may admit evidence that the party committed any other sexual assault. Since the evidence complained about by Trump was permitted under that rule, the issue becomes whether the judge abused his discretion in failing to exclude the relevant evidence under Rule 403, which provides that a judge may exercise his discretion by excluding relevant and admissible evidence if its probative value is substantially outweighed by the danger of unfair prejudice to the party that it's being used against. Arguing abuse of discretion in applying Rule 403 is generally viewed as a losing argument. Even after that first jury verdict, and this highlights one of Trump's serious mental issues, in my opinion, he continued to claim that Carroll had fabricated the sexual assault claim and called her a whack job. In other words, he repeated the statements found to be defamatory by a jury after the jury verdict. Those statements were subsequently added to the second jury trial, to the defamation claims in the second jury trial, of course. Trump was collaterally stopped from presenting evidence or arguing that those statements that he made were not legally defamatory under the doctrine known as collateral estoppel, which has been around for centuries. Once a jury decides an issue, as it did in the first case that Trump's statements were legally defamatory, that finding is binding on the parties and cannot be relitigated until and unless the first jury verdict is overturned on that issue. Repeating the claims about Carroll after a jury found the statements defamatory led to the huge $65 million punitive damage award in the second case, which has been appealed as well. No sane person would have repeated the statements after a jury had already found them defamatory. If the first verdict is not set aside by the appellate court, the second jury verdict finding Trump liable for sexual assault and defamation will likely be upheld as well. It is consequently critical for Trump to convince the Second Circuit in the pending appeal to throw out the first jury verdict and order a new trial. That would require a new trial on the second jury verdict that had the huge punitive damage award as well, since Trump's liability in that case had already been decided based on the first jury verdict under the doctrine of collateral estoppel, as I just discussed. I would not expect a decision before the election, though one is certainly possible. The issues are not complex for an appellate court panel. Most likely, the panel met to discuss the case after the oral argument, made a preliminary decision on the case, and one judge was assigned to write the opinion. If the first jury verdict finding Trump liable for defamation is upheld, then Carroll could file a third defamation suit against Trump, seeking more punitive damages since Trump continues to claim that she lied about the sexual assault, including statements he made yesterday after the Second Circuit oral argument. Would a $1 billion punitive damage award shut him up? Would 10 billion, 20 billion? I'm not sure how much it would take to make him shut up about making the claims found to be defamatory. Yesterday, after the oral argument, Trump repeated his claims that the jury had already found to be legally defamatory. Why do that? Everyone already knows his position on Trump's claims, so making them again informs no one of his position. Referring to Carroll, Trump said yesterday, quote, all these are in quotes, never met her, never touched her, and that she had, quote, fabricated, end quote, the sexual assault claim. Trump also claimed that another woman, Jessica Leeds, had lied during her testimony at the first jury trial when she claimed that Trump had sexually assaulted her. Leeds also claimed that she saw Trump years later at a charity event where Trump said to her, quote, I remember you, you're that cunt from the airplane, end quote. As I discussed in an earlier video, Trump had called Carroll's attorney Roberta Kaplan a cunt off the record during a deposition. His attorney made sure that a comment that he was about to make was off the record, and Trump then said to Kaplan, see you next Tuesday. That phrase combines words that sound like the first two letters of the slur, see you, along with the words that start with the letters N and T, next Tuesday.